Welcome to Audit the Audit, where we sort out the who and the what and the right and wrong of police interactions. This episode covers stop and ID laws, obstruction, and unlawful seizures, and is brought to us by Long Island Audit's channel. Be sure to check out the description below and give them the credit that they deserve. On October 31st, 2022, officers DiNatale and Yeldell of the Trenton Police Department stopped Mr. Daniel and Ms. Myra on the street after being dispatched to a call that described a male and female in a gray truck with Pennsylvania tags. Long Island Audit stated in his video that the officers were responding to a call regarding a custody dispute, although Mr. Daniel and Ms. Myra's role in the alleged dispute was unclear. The interaction that followed was captured on Officer DiNatale's body camera.
Somebody else was riding in the truck with you? Y'all just got out of the truck?
Wait, you're saying somebody riding it?
Y'all just got out of this truck, right?
No. Parked there for a while.
Were y'all just sitting in the truck?
I mean...
Yes, right? You was just sitting in the truck?
You're just sitting.
What?
I don't answer questions. I don't want to incriminate myself, so... You're not incriminating yourself, you're answering a question. Which can potentially incriminate myself, so I don't answer questions. We were here for a long time.
No, I'm not worried about if you was here for a long time or not. It's pertaining to the call, but you're not in any trouble.
We're here for a call for service. We're trying to see if my partner's asking you a question to see if you pertain to the call. If you don't, then you'll be on your way, and we'll be on our way handling our job. No, it's fine. I understand. There's no need to get smart with me. No, I'm not trying to get smart with you. I was just saying, like, I don't want to get in trouble for doing nothing wrong. Okay. You know what I mean? I'm just standing here. There's no need to get smart with a police officer. I wasn't trying to get smart with you. Okay. Keep it that way. I'm not trying to give you a hard time. Keep it that way. Can you give a description of the vehicle?
Said it was a Dodge Ram truck, red in color, and she gave me a plate.
You guys get a call for a Dodge Ram truck? Yes, we got a call for you too. Place, so you guys pull up here? And you have a responsibility to check it out. If you guys are doing nothing wrong, then you guys are doing nothing wrong. That's fine. I'm just curious. Do you guys have IDs just so I can see who I'm talking with? I do, but I don't feel like I have to give it to you. Well, you do. I don't. I'm telling you, you do. In the state of New Jersey, it's an non-ID state. I haven't committed a crime.
Officer DiNatale demands Mr. Daniel identify himself as part of an investigation, and Mr. Daniel refuses, arguing that New Jersey is not a stop and ID state. As we have discussed many times here on ATA, stop and identify statutes are laws that authorize law enforcement officers to arrest citizens if they refuse to identify themselves under certain circumstances. Beginning with the landmark Terry case, the Supreme Court has consistently recognized that an officer's reasonable suspicion that an individual may be involved in criminal activity allows the officer to briefly detain them and take limited additional steps to investigate the situation further. Although it is well established that an officer may ask a suspect to identify himself during a Terry stop, prior to 2004, there was an open question regarding whether a suspect could be arrested and prosecuted for refusing to answer. This issue was resolved in the case of Hybel versus Nevada, where the Supreme Court held that Terry principles authorize states to enact laws requiring suspects to disclose their names if they are legally detained based on reasonable suspicion. In upholding an individual's arrest for refusing to identify himself, the court in Hybel emphasized that the Nevada statute was, quote, consistent with Fourth Amendment prohibitions against unreasonable searches and seizures, and that the stop in question was based on reasonable suspicion. However, because New Jersey is not a stop and ID state, New Jersey police officers typically cannot arrest an individual for refusing to identify themselves outside of a traffic stop, unless the officer is making an arrest or issuing a summons. Additionally, officers cannot compel individuals to identify themselves under threat of arrest without reasonable suspicion that they are involved in illegal activity, even if the state has a valid stop and identify statute in place. Long Island Audit reported that the officers were initially called for a custody dispute rather than a criminal offense, and although this information has not been externally confirmed, Officer DiNatale stated that the officers were responding to a call for service, and that their investigation did not mean Mr. Daniel had done anything wrong. Because it does not seem that the officers had the reasonable suspicion necessary to detain Mr. Daniel, it is unlikely that a court would find that Mr. Daniel was obligated to identify himself in this situation, even if New Jersey had a stop and identify law in place.
I haven't committed a crime. Can I have your name and badge number, by the way? Your badge number. I need your IDs.
I need you guys' name and badge numbers. I'm interacting. I don't even know who you guys are. I'm interacting with police. You guys need to identify.
Right now.
Clear identifiers.
Okay, but I don't.
Cameras are running.
Why are you intimidating me like this?
I'm not intimidating you.
You came up to me really aggressively.
I'm not intimidating you.
Why are you being aggressive like this? I haven't committed a crime. You're trying to ID me. I haven't done anything wrong.
We got a call. My dispatchers are giving your vehicle with you guys being described.
You're trying to jump the gun and do wait. You're not.
331.
I'm not trying to cause any problems.
So we got called here, right? When we got here.
Alright, Tepper, what's the complaint about? Because we're out with these two parties. We're trying to identify them and
because
figure out what's going on.
The truck was identified. Not you, not her. I asked whether or not you would sit in the truck because something could have been wrong with her, something could have been wrong with you. That's why I asked you, right? But then you got smart with me.
I wasn't trying to be smart. I wasn't trying to be smart.
We have an obligation, right? When we're talking with people and we get a call. And I'm not saying you two are doing anything wrong. But I'm going to call my dispatcher, as you heard on my radio, and I turned it up so you could hear.
Right.
Male, female, Dodge Ram truck.
That's it. Did I do something wrong? No.
So I'm asking you to identify yourself.
And I am refusing to identify myself because I have not committed a crime. And in New Jersey, this is a non-ID state. I refuse to identify myself. You asked me, and I refused. I feel like
this is an investigation, and I'm asking you to
so
investigate.
Investigate.
And
it's fine.
you
investigate.
And
I am not going to
your name.
identify myself.
So now you're obstructing. So
I'm not obstructing. Obstructing.
The officer places Mr. Daniel in handcuffs, accusing him of obstruction for refusing to identify himself. Section 2C 29-1 of the New Jersey Revised Statute states that, quote, a person commits an offense if he purposely obstructs, impairs, or perverts the administration of law or other governmental function, or prevents or attempts to prevent a public servant from lawfully performing an official function by means of flight, intimidation, force, violence, or physical interference or obstacle, or by means of any independently unlawful act. In the 1985 case of State v. Pearlstein, the Appellate Division of the Superior Court of New Jersey expressly indicated that the application of this statute is, quote, limited to situations where there is violent or physical interference, or where other acts occur which are unlawful independently of the purpose to obstruct government. Based in part on this decision, the same court held in the 2005 case State v. Camillo that an individual's failure to identify himself was insufficient to support a conviction for obstruction. In this case, the court held that Mr. Camillo's refusal to provide his name, date of birth, and social security number to a state trooper who needed the information to prepare an incident report did not constitute obstruction under Section 2C 29-1. While Trooper Dykeman gave Mr. Camillo an ultimatum and said that he would be arrested and charged with obstruction if he did not provide the requested information, the court noted that, quote, simply obstructing, impairing, or perverting the administration of law or the governmental function was not a statutory violation, and that, quote, the obstruction must be carried out in a manner described in the statute, by means of flight, intimidation, force, violence, or physical interference or obstacle, or by means of any independently unlawful act. Because Mr. Camillo did not physically interfere with Trooper Dykeman or otherwise violate the law, the court ultimately concluded that while Mr. Camillo's actions may have obstructed the trooper from preparing his report, his conduct was not a violation of the obstruction statute. Based on this precedent, it is unlikely that a court would determine that Mr. Daniel committed obstruction by refusing to identify himself, even if his refusal actually limited the officer's ability to investigate.
I'm requesting a supervisor. I'm requesting a supervisor. I did nothing wrong.
No.
Relax.
You're obstructing.
I'm not obstructing.
Man, back up. You're going to be arrested too.
Back up.
I'm requesting a supervisor. Do not consent to searches and seizures. I do not. This is against my First Amendment. This is against my Fourth Amendment. Why are you putting me in? Why are you? Okay, I will get in. I'm not resisting. He's sticking in my pockets. He's sticking in my pockets.
No, what are you doing?
I'm patting you down. It's called search.
I want your badge number.
Okay, it's Officer Detail 7.
I'm requesting a supervisor.
Have a seat in the car.
I'm requesting a supervisor.
I want a supervisor. You're intimidating me.
My wallet's on the floor.
Excuse me. Excuse me. Oh my God, don't touch me. Oh, I didn't do anything wrong. This is my legal right.
Stop.
This is my legal right. Don't touch me. Don't touch me. Don't touch me. I'm uncomfortable. Don't touch me. I'm not fighting.
Is this your phone right here?
I want my supervisor. Baby, what? I know. I want a supervisor.
Both disorderly persons obstructing an investigation, didn't want ID. Told him he was being detained, didn't want to provide identification. Female started getting rowdy, started grabbing at us, tried to prevent us from searching him, incidental to arrest. Both are under arrest for disorderly person. So Daniel, I want you to understand something. When the police are conducting an investigation, right, doesn't mean you're doing anything wrong.
Right.
But you have to identify, okay? It's called search incidental to arrest. So I pat you down, and I have to pat everywhere.
All right, but I'm being illegally arrested because I haven't committed a crime.
But it's not. It's called...
Not identifying myself is not illegal.
You're obstructing the administration
I'm not
of investigation.
obstructing an investigation because I'm not identifying myself. That's not obstructing. I'm just trying to explain to you guys that I don't have to identify myself. I'm letting you guys know, look, I believe I'm a strong believer. I have identified myself, yes, of course. I'm being placed under arrest, so lawfully, under the law, I have to identify myself. Being suspicious is not a crime. I don't have to identify myself. So it's not obstruction.
So remember how I was saying dispatch? What I said our dispatchers are telling us? A male and a female in a Dodge Ram gray color pickup truck.
That's fine. That's fine. But you haven't observed any crime. I'm just standing.
So we have a right to
investigate.
To investigate.
Correct.
And
that's not asking.
Identify.
Right. You can ask me for identification. I can refuse to identify.
And if the party refuses, the police officer has an obligation to now, if they refuse to give information, we now detain. If they still refuse, it's an arrest.
Officer DiNatale claims that members of law enforcement have the authority to identify citizens during investigations, detain them if they will not identify themselves, and then arrest them if they still refuse to identify. Officer DiNatale seems to be referring to the three basic levels of police interactions: consensual encounters, investigatory detentions, and arrests. During a consensual encounter with a citizen, officers can ask questions, including an individual's name, without any suspicion they have committed a crime. However, as the Supreme Court stated in the 1983 case of Florida versus Royer, the individual, quote, need not answer any question put to him, and, quote, he may decline to listen to the questions at all and may go on his way. In order to detain an individual and prevent them from leaving a scene, officers must have reasonable suspicion that the individual is involved in criminal activity. And as the Royer case specifically noted, an individual's refusal to listen to an officer, answer their questions, or identify themselves during a consensual encounter does not, without more, furnish grounds for detention. Although reasonable suspicion is a less demanding standard than probable cause, inarticulate hunches and an officer's good faith beliefs are insufficient to justify a detention. And, contrary to Officer DiNatale's assertions that an officer can detain a citizen for refusing to identify themselves, an officer must be able to point to an objectively reasonable basis for suspecting criminal activity in order to detain a citizen. Finally, for an officer to have the legal authority to arrest an individual, they must have probable cause, which is a more demanding standard than reasonable suspicion that requires an officer to have sufficient information for a reasonable person to believe that the individual had committed a criminal act. Based on the body camera footage, a court would likely conclude that Mr. Daniel's detention was unlawful, as it did not seem that the officers had reasonable suspicion that Mr. Daniel was committing a crime. And, contrary to Officer DiNatale's assertions, an individual's mere refusal to identify themselves during a consensual encounter does not give rise to the reasonable suspicion necessary for an investigative detention. Likewise, a court would probably determine that Mr. Daniel's arrest was also unlawful because he did not have a legal duty to identify himself. And, as we discussed earlier in this episode, refusing to identify is not sufficient to support an obstruction charge.
You can
detain for not identifying.
Can we please speak to a supervisor at the station?
You're going to. You're literally going to see a supervisor.
Thank you.
All right?
Yes, thank you.
After their arrests, Mr. Daniel and Ms. Myra were both charged with obstruction. In his video, Long Island Audit reported that the prosecutor offered to drop the criminal charges in exchange for a civil fine, and Mr. Daniel and Ms. Myra refused the offer because they wanted to hold the officers responsible for their actions. He also stated that they are looking for an attorney to file a civil rights lawsuit, and that Mr. Daniel and Ms. Myra had another court date on January 17th, 2023. Long Island Audit stated that an update video would be posted, but an update has yet to be made as of the date of writing this episode. Overall, Officer DiNatale and Officer Yeldell get an F for failing to conduct a legitimate investigation before attempting to identify anyone on the scene, maintaining a rude and condescending attitude throughout the encounter, and for escalating a peaceful interaction into a physical altercation and likely an illegal arrest. Rather than contacting the individual who made the 911 call to confirm the complaint, the officers turned their attention to Mr. Daniel and Ms. Myra for refusing to answer a consensual question. At no point was the couple legally obligated to answer any of the questions asked of them by the officers, and their refusal should never have been perceived as grounds for intimidation. Like many other members of law enforcement featured on this channel, the Trenton officers were mistaken about the scope and language of their state's obstruction statute and made an arrest based on this misinterpretation. This fact alone will likely afford Mr. Daniel and Ms. Myra an opportunity to contest the legality of their arrests and potentially file a legal claim for several different constitutional violations. This interaction highlights the importance of officers having a thorough understanding of the laws they are attempting to enforce, and the critical role that de-escalation plays in preventing unnecessary and potentially illegal arrests. Mr. Daniel and Ms. Myra get an A- for refusing to identify themselves when they were not legally obligated to do so, choosing to remain silent rather than potentially incriminating themselves, and for standing up to the officers despite their intimidating conduct and threats of arrest. When the Trenton officers arrived on the scene, Mr. Daniel and Ms. Myra were under no legal obligation to remain on the sidewalk, and it may have been in their best interest to leave the area immediately upon their arrival, rather than standing around and waiting for an engagement. It's also important to note that the right to remain silent must be verbally invoked in order to trigger the protections offered by the Fifth Amendment. Telling an officer that you, quote, will not answer any questions is not enough to render any statements inadmissible in court. And even silence can be used in court as evidence against a citizen. As discussed in many previous episodes, in order to properly invoke the right to remain silent, citizens must verbally state that they are invoking their Fifth Amendment rights before choosing to remain silent. I commend Mr. Daniel and Ms. Myra for having the courage and conviction to stand up for their rights. Be sure to check out the Long Island Audit channel for future updates on this case. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.